They're going to owe me a bunch of dismissals.
I gave the dismissal form to Mr.
Oh,
Nando.
that's right. It was in the earlier ones for.
Yes.
Sorry. Good afternoon. This is Judge Elisa Bettis presiding over the 210 District Court criminal docket for June 20th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I will just advise everyone, this is day number, I don't know what, without Odyssey. Odyssey is down. So it had been intermittent, so we're limited. I may be asking questions that I should know, but we do not have access. I do not have access to Odyssey. So with that, let's get annexed. Can I get Edgar Munoz, please? Good afternoon, Mr. Montes.
Judge, did you activate the function or will it be consecutive?
No, we will activate it. Let's go
Okay.
ahead and do that. And then annex, if you can select Spanish. I think it's there.
We're ready?
Okay, if you'll just select Spanish, please. Select English.
Sí.
Calling cause number 2022-0D0 4557, State of Texas versus Edgar Santiago Munoz. May I have announcements, please?
Preston Munson for the state is ready, Your Honor.
Good afternoon, Your Honor. Jose Montes for Edgar Munoz. We're ready.
And Mr. Munoz is appearing remotely today. I just need to confirm, we did get the waiver on Mr. Munoz. Is that right, to do the plea via Zoom?
Yes, Judge, for Mr. Munoz, we did.
Okay, Mr. Munoz is appearing remotely from the annex for today's plea, and he is utilizing the assistance of a court interpreter, Ms. Patricia Hernandez. Mr. Munoz, I have received the plea documents in your case to include your consent to conduct this plea over Zoom. Is that correct? You are in agreement with that?
Sí, de acuerdo.
Okay, Mr. Munoz, in order to go forward, I need to swear you in. If you would raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Sí.
Yes, sir, you can put your hand down. Thank you very much. Would you state your name and date of birth for the record, please?
Edgar Santiago Muñoz Navarro, 11-29-91.
Mr. Munoz, I did receive documents from your attorney indicating that you did intend to plead today, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Munoz, do you recall reviewing the plea papers with your attorney and signing that document?
Sí, así es.
Did you understand everything contained within that document?
Sí.
Mr. Montes, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor, and I asked him if he had any questions and he understood everything.
Okay, do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I believe he does, Your Honor.
Mr. Munoz, are you satisfied with your attorney's representation of you?
Sí.
Mr. Montes, any reason to believe your client is not presently competent to enter his plea?
No reason, Your Honor.
Mr. Munoz, have you ever been found mentally incompetent by any court?
No,
Have you ever been examined by a doctor or psychiatrist who has found you mentally ill?
no,
So based on your testimony, your attorney's representations, and my observations of you today, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
no,
Do you have any legal status in the United States? And are you a resident? Do you have any kind of permission to be in the United States?
no.
Mr. Montes, did you have an opportunity to discuss the immigration consequences of his plea with him?
I did, Your Honor, thoroughly.
Well, let me ask Mr. Montes, what did you advise him in terms of the immigration status and his plea?
Your Honor, I advised him that upon his conviction, very likely he would be deported. I advised Mr. Munoz that if he were to apply for readmission illegally, he may be denied because of this conviction. I also advised him that if he were to apply for citizenship, that this may deny his citizenship application.
Mr. Munoz, were you able to discuss with Mr. Montes or any other legal counsel the immigration consequences of your plea today?
Sí, así es.
And all of what Mr. Montes advised, the court will also advise you of, to include any other number of consequences that we can't foresee. What I mean by that is that immigration law changes all the time. And so certainly if you entered the country again, if you attempted to get some type of legal status in the future, we cannot predict the future. This could be detrimental to all of those. Of course, and deportation, all of those things. Did you understand that?
Sí, así es.
And with that understanding, do you still want to go forward with your plea today?
Sí,
Okay, in this case, you were charged with, looks like 8 counts, but I understand the plea is just as to counts 1 and 2, with smuggling of persons for a pecuniary benefit. As to counts 1 and 2, individually, what is your plea? Guilty or not guilty?
culpable.
And that's as to both counts, Mr. Munoz?
Así es.
Okay, are you making your pleas freely and voluntarily?
Sí,
I will find you are making your pleas freely and voluntarily. Mr. Munson, would you summarize the evidence, please?
This case would have proceeded to trial. The state of Texas would have proven beyond a reasonable doubt on or about the 9th day of August 2022 in the county of El Paso, state of Texas. Defendant did then their attempt to use a motor vehicle to transport individuals, namely Luis Sanchez Juarez and Robin Vasquez, with the intent to conceal them from a peace officer. And at this point, we moved to admit State's Exhibit 1, the plea papers, and State's Exhibit 2, 3914.
Let me just ask for clarity. I had down that, what is the actual charge that he's pleading to, Mr. Munson?
He is pleading to the lesser included attempted smuggling of persons, and that is a state jail, and we are under 1244A. We're punishing him as a misdemeanor.
Okay, so I apologize. I had written down that it was for the actual charged offense. I'm just now seeing the notation. So Mr. Munoz, let me clarify for the record. The pleas as to counts 1 and 2 are for a lesser included offense of attempted smuggling. And so do you still wish to enter pleas of guilty as to those 2 charges?
sí,
Okay, I just wanted to make that clear. Okay, what is the, did you ask for admission of your exhibits, Mr. Munson?
Yes, Your Honor. We moved to admit State's Exhibit 1, the plea papers, and State's Exhibit 2, the 3914.
We had no objection, Your Honor.
States 1 and 2 are admitted. What is the plea agreement?
Under 1244A, he is to get 280 days confinement in the El Paso County Detention Facility, credit for time served, And then counts 3 through 8 will be dismissed.
Mr. Montes, is that your understanding of the plea agreement?
It is, Your Honor.
Sí, muy bien.
Ms. Hernandez, I thought I could hear you there, so. Okay, and that was my next question, Mr. Munoz, if that was your understanding of the plea agreement.
Sí, sí, sí.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Mr. Munoz, do you recall reviewing the trial court certification with your attorney and signing that document?
Sí.
Was signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. I will find you guilty in counts 1 and 2 of attempted smuggling of persons, and I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 280 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. I also will sign dismissals as to counts 3 through 8 once I receive them. Is there anything further, Mr. Munson?
I'm sending the dismissal now and nothing further, Your Honor.
Mr. Montes?
Nothing further, Your Honor. May I be excused?
You may. Thank you very much,
Thank you, Your Honor.
Mr. Munoz. Mr. Munson, is that all you have today?
Yes.
I have also Jesus Soto, but I believe
I think that one, is that Mr.
Yanez.
Yanez's? That was
yeah, I
reset.
believe- Okay, thank
It's
you.
gonna be reset. So last call, anyone else needs the interpreter? Can you go ahead and turn off the function, Mr. Munoz?
Your Honor, I had a probation case that my client does require an interpreter.
Who is it?
I don't know if we, Victor Miller. He doesn't speak any English, Judge.
Okay,
But
so
I-
let's get Victor Miller and let's turn on the function again. And if Annex, if you didn't, I think you have to pick Spanish again and everybody
Yeah,
else
no,
select
We
English.
have Mr. Lopez also needs an interpreter, okay?
Sergio Lopez, did we
Yes.
get that? That one is gonna be reset, I think, right, Mr. Huffman?
Yes, Your Honor.
Thank you, Annex.
Yeah, yes, ma'am.
Sí.
All right. Okay, let's get started on Mr. Miller's case.
In cause number 2022-0D03762, State of Texas versus Victor Manuel Miller. Announcement of counsel, please.
Carlos Ruiz about probation.
Who's here for the state?
I show Mr. Hoffman
For the state, it's Mr. Vandenberg.
or Mr. Randall.
I'm here, Your Honor. It seems to be a BPU
Please
case.
select English, Mr. Vandenberg.
I think he's right. It is a BPU case.
Oh,
But
Can you
he's
hear me
on
now?
probation already, so I don't know if that's still the BPU.
I would expect that to be BP, Your Honor. That's what my understanding was.
Okay.
oh, Mr. Munson just left.
I can get a hold of him. Let me just confirm.
I send them a message, Judge.
I don't know if Mr. Munson always handled the, I feel like we've been here on this case before. I just can't remember who handled it.
Honor, Mr. Vandenberg
I believe what's here. I'm sorry, he covered one time in May and then Ms. Elizalde covered the last hearing as well.
Well, I can cover for Mr.
Is that him, Mr. Marupo?
Yes, Judge, he's here.
Carla or Mr. Ruiz, are you covering on Mr. Miller?
Yes, Your Honor.
Judge, the last time we were here, the court wanted to do an evaluation and there was an issue on whether or not Mr. Miller was being upfront in his last evaluation, so the court wanted to do another one with the understanding that he would be honest this time. And that's kind of where we left off.
I appreciate that, but I'm just trying to see if I have a case summary. So who's covering Mr. Miller's case from probation?
I am, Your Honor.
Mr. Reese, I need you to select English, please. Mr. Ruiz, are you covering?
Yes, Your Honor. You said it was right.
This is Victor Miller. Let's go ahead and call it, Mr. Manufo. If we did we already call it?
We called it, but I can call it again, Judge.
That's okay. Okay, so Mr. Vandenberg, you're covering, Mr. Ruiz is covering for probation. Mr. Huffman is here on behalf of Mr. Miller. My apologies, Mr. Hernandez. I forgot you were interpreting. Mr. Miller. Mr. Miller is utilizing the assistance of a court interpreter. We are back for probation status hearing. Mr. Ruiz, why don't you tell me what has happened since we were here last?
Yes, Your Honor. So last court hearing, Your Honor requested Mr. Miller to be screened for BHRTC or Aliviane. He has been screened for BHRTC. He does not meet criteria. He only meets criteria for TAP, supportive outpatient. And then for Aliviane, he does have an appointment tomorrow at 1:30 p.m., Your Honor. And that's where we are right now.
Is Aliviane inpatient?
Yes, Your Honor.
Yes.
That's a 90-day program.
Yeah, I'm pretty sure I wasn't even really at treatment. Mr. Huffman, what was your argument for treatment?
Well, Judge, I don't know. I wasn't really arguing for treatment.
So you want time?
No, Judge. He's a very young man. He started off on the wrong foot. He had issues at the house, and he's also suffering from depression. And I think he just needed to kind of get scared straight. And I think he's kind of learned his lesson, Judge. And Mr. Miller's he's ready to do the things that he needs to do, and we're hoping that he's given the opportunity.
Okay, so the appointment is tomorrow?
Yes, Your Honor.
Okay, let's go ahead and come back on Thursday at 10 a.m. I'm gonna, well, I don't know, Mr. Well, no. Can't do that. We're gonna come back in 1 week. 1 week to see the results of that evaluation regarding Aliviane. Mr. Reese, can you tell me a little bit, for example, at the inpatient Aliviane, I mean, are they fairly well restricted from being able to leave? How does that work?
Your Honor, I'm not very familiar with the program itself. It's like
Okay.
An outside source from the department. Okay,
if you can get me some of those details. I do not want him immediately going back home and doing some kind of outpatient treatment. Can you tell me also, Mr. Reese, what is it that keeps him from qualifying for BHRTC? Is that he has not done anything kind of?
Your Honor, for that, there is no positives. Like I have no positive UAs, nothing like that. That's the main reason that he doesn't qualify.
Oh, yeah, because he never showed up. Okay, alrighty, we'll come back in a week.
Okay, Your Honor.
Straightforward. Thank you. And Mr. Ruiz, if you could, if you can get some of those details on the, how well secured they are at Liviane for inpatient, please.
Yes, sir.
Appreciate it. Thank you.
Thank you.
Okay, let's take off the interpreter function. And hopefully I can say, Ms. Hernandez, you can leave. Does anybody else need an interpreter? All right, Ms. Hernandez, thank you for your time.
Judge.
Appreciate you. Take care.
You too, Judge. Thank you.
So who's next?
Middle of page 14, Judge.
Mhm.
Annex, may we have Manuel Castro?
Yes, sir. Castro, back down.
Mr. Eras, this is yours.
Yes, Judge. Good afternoon.
Good afternoon. Go ahead and call it, Mr. Manufo.
In cause number 2022-0D03647, State of Texas versus Manuel Castro. Announcement of council, please.
David Vandenberg on behalf of the state.
Alex Shawala from Mr. Castro. We're ready, Your Honor.
And Mr. Castro is appearing from the jail annex. We are set for probation status hearing. How about Mr. Eras, you give me an update?
Yes, Judge. Good afternoon. Mr. Castro was placed on probation back in January for a term of 5 years, deferred probation for an aggravated assault with deadly weapon. Mr. Castro never reported to our office, Judge. Back in February, I had spoken with his mom, and his mom had reported to me that Mr. Castro had left her household. He had gone to live with his father. She reported that once he got out of jail, he went back to using meth. And that was just a big argument for them. So he ended up going and living with his father. But she didn't have any information as to where he was residing, or she didn't have a valid number for him. In April, Mr. Castro was arrested for possession of paraphernalia by the sheriff's department. They were called to his residence. They caught up with him, and he was caught with a pipe. Pipe had residue, and the residue, I guess, was tested for meth. There was, I believe there is a motion that's been filed. At the last hearing, Judge, back on June the 5th, I guess the court was inquiring as to Mr. Castro qualifying for the BHRTC program. So he was seen in jail by one of our counselors. The counselor determined that it was best to put him in a controlled environment. She determined that he had a severe disorder for amphetamine use. So we went ahead and we sent the referral to BHRTC. However, since he hasn't done any treatment, BHRTC said to go ahead and start him off with the TAP program. I did get him screened for the substance use caseload, and he does qualify for that. The only thing is they wanted him to participate in the TAP outpatient program. So I did contact the original counselor who saw him in jail. And she did say that, she would put him in TAP outpatient if the court wanted him to.
Over in the case summary, it's highlighted here as to TAP assessment day recommendation is for residential program.
Yes, Judge.
Yeah, I'm not gonna, Mr. Shawala, it's BHRTC your time, honestly, with your client. And that will be if he's inclined to have some type of treatment, that will be the court's concession. But yeah, I'm not really.
When our preference, Your Honor, I think would be the BHRTC. As we've discussed, Mr. Castro, if you're revoked because this is an aggravated case, you'll serve 2 years flat, even if they gave you the minimum. And I don't know that Judge Pettis would do that, but even if she were, you got to do 2 years flat. There's no parole on an aggravated. So, I think BHRTC would be the better option for you. That's a treatment program. It's certainly shorter than 2 years. And I think might put you in a better place. Is that what you'd like to do? Mr. Castro?
Castro, your attorney is talking to you.
Yeah, that would be a great idea.
And as I think, thank you, Mr. Shawala. I think in the past, Ms. Pineda has, kind of thrown it back. If I order it, he can go, and that is going to be the order, is for him to go to BHRTC. I did look at this case, and there's, unless he was telling me he just wanted to do his time, that's the only treatment I'm going to go with him. So, Mr. Vandenberg, do you have any input?
I do, Your Honor. The state's concerned that this is, the underlying charge is aggravated assault with a deadly weapon. The facts are that he was under some kind of intoxicating influence.
He got an axe towards his dad.
Pickaxe, struck him, tried to strike him twice. And we're concerned that without treatment or incarceration, he will attack other people, including family members. So the minimum is BHRTC, but we would, prefer jail time, confinement if this does not work.
Mr. Shawala, if I remember correctly, I was trying to look back in terms of a mental health issue, and I feel like I didn't see anything on a 1622 or anything like that. Have you come across anything? Mr. Eras, I'll ask you, is he on any mental health caseload?
Not that, no, Judge, he's not.
Do we know?
And I've not seen anything like that, Judge.
Oh, okay, all right. Then the order is BHRTC. This is his one shot to clean up.
Thank you, Judge. We appreciate it.
With that, Mr. Castro, so because I don't know that this was on the table, BHRTC, that treatment program requires that you remain in custody until they can find you a bed at BHRTC. That can be weeks. I will refer you to your attorney for any other information, but generally that's how it goes. So Mr. Eras, if you anticipate there's any kind of delays, please let me know immediately. Otherwise, I'll look for the mods to send him to BHRTC.
Yes, Judge, I'll go ahead and I'll prepare them and I'll forward them to the court.
I appreciate that. Thank you very much. Is there anything else on this case?
Not from the state, Your Honor.
Not from the defense. Thank you, Judge.
Thank you for your time. Who's next? Thank you, Mr. Castro. Thank you, Mr.
Good luck,
Eras.
Mr. Castro. Maybe excuse.
You may. Is that the only one you have, Mr. Eras?
Yeah, yes, Judge.
Okay, thank you.
Thank you.
Who's
Bye-bye.
next?
Page 17, Judge. Annex, may we have Morris, Eddie Morris?
Sir.
Good afternoon, Judge.
Hi, Ms. Solis. Is Mr. There he is.
Hello.
Mr. Bruce, howdy.
How you doing, Your Honor?
I'm well, thanks. All right, go ahead and call it.
In cause number 2018-0D01845, State of Texas versus Eddie Morris. Announcement of counsel, please.
David Vandenberg on behalf of the state.
Solis on behalf of Mr. Morris, Your Honor, ready to proceed.
Dave Bruce, no probation.
All right, and so this is like I don't know what time, how many times we've been here on Mr. Morris, and I think it was pretty clear last time. Mr. Bruce, I think you and I have missed each other. I think you were here when Judge Beasley was covering, but I did observe that hearing. I'm a 3 TDC, period.
Yes, Your Honor, I spoke with Mr. Morris and I did get the plea of true paperwork forwarded to me. We also did a jail credit calculation, but Mr. Morris wanted one last attempt to see if we could do the 2 TDC. I did email Mr. Lizalde, and I know the final plea rec is for the 3 TDC, Judge. And I have spoken with Mr. Morris quite a few times over the phone.
Okay.
And I think his credit is quite a bit. As of May 31st, he was at 544. I was double checking on that because he claims there might be some days I'm missing, but that's what I have.
Miss Welch, are you here?
I'm here, Judge.
Oh, okay, there you are. The docket only reflects 132 days, but do you show a time credit? If so, maybe you can just shoot that to Ms. Solis in either in the chat or via email.
Yes, I'll calculate it right now and I'll send it in the chat.
Okay,
Perfect, thank you.
and just I'll have you reset for a probation status in 3 weeks, anticipating that will be a plea of true unless there's an issue. Okay, Ms. Solis?
Yes, Your Honor, and I'll be going to see Mr. Morris at the annex tomorrow or the day after. It'll be within a day or two.
Thank you very much. Thank you for all your efforts in this case.
Thank you, Judge.
Thank you. Thank you, Mr. Morris. Mr. Bruce, thank you very much. Who's next?
Thank you, Your Honor. May I be excused?
You may.
Middle of page 19, Judge.
Oh, may I be excused, Judge? Sorry.
Yes, ma'am. As long as you get the info you need. If not, Ms. Welch's, you can email her.
Oh, I'll just wait.
That
I'll
time.
go ahead and email her.
Okay, perfect.
Okay, thank you. Bye-bye.
Okay, who's next? I'm sorry.
Middle of page 19, Judge. Annex. May we have Guillen Perez?
No, sir. That is, yeah.
This was 365, right? Mr. Vasquez, you there?
Yes, Your Honor.
Okay.
Yes, Your Honor, it should be 365.
Mr. Pettis, is that you?
Yes, Your Honor.
Okay, let's get started.
In cause number 2021-0D02039, State of Texas versus Guillen Perez. Announcement of counsel, please.
David Vandenberg on behalf of the state.
And Joseph Vasquez representing Mr. Pettis. And we're
And
ready,
Mr.
Judge.
And Mr. Pettis is appearing remotely from the jail annex. I just want to confirm, did we also get the waiver or consent to do a virtual plea in this case?
I believe there was one included, Judge. Let me check my paperwork.
Okay, if you will, please. Mr. Pettis, while your attorney is double checking the paperwork, I have you scheduled for a plea of true today in this case. We are obviously on Zoom. Let me ask you, are you consenting to do this on Zoom, knowing you can do this in person?
Yes, Your Honor.
Do we have?
Judge, no, Judge, there were only the plea papers and the motion to revoke.
Yeah, we're gonna have to reset him for 1 week. I need it in writing. We'll see you in 1 week, Mr. Pettis.
Can someone email me the form so that I'm gonna be at the jail on Thursday.
Mr. Vandenberg, do you have that? Does that usually go out with the?
I can get that to Mr. Vasquez.
Okay. 1 week. All right. Thank you,
Thank you,
Mr.
Judge.
Vasquez. Who's next?
Bottom of page 19, Judge. Annex. May we have Eric Silva?
No, sir.
Do you have the PSR on him, Mr. Manuel?
Yes, Judge. I just ran him right now.
Can you email it to me, please?
Yes, Judge.
Your Honor, can you give us a minute? He's next door. We gotta transport him back.
Absolutely.
Thank you.
On its way, Judge.
Is that Mr. Silva?
Yes, ma'am, Mrs. Silva.
Okay. Mr. Vandenberg, are you ready?
I am, Your Honor.
Okay, call.
In cause number 2022-0D-05442, State of Texas versus Eric Silva. Announcement of counsel, please.
David Vandenberg on behalf of the state.
Leonel Nunez on behalf of Mr. Eric Silva.
Mr. Silva is appearing remotely from the jail annex. We are scheduled for a bond hearing. Mr. Nunez, please indulge the court. What is the bond amount? Odyssey is not the most
It
friendly.
is at 100.
Is this
100,000, Your Honor? Yes, Your Honor.
Okay, all righty, go ahead.
Well, Your Honor, as you know, the bond is set at 100,000 right now. He's been incarcerated since March 10th. So he has been in there for some time. He's a U.S. citizen. He's 41 years old. He's resided in El Paso his entire life. He is married and has a 12-year-old daughter. He has informed me that if he were to get out, he would still have a job at the glass house. That is his trade. He is a glazer. He is the sole provider for his family. He wants to be able to get back out to work, be able to provide for his daughter, also help out his wife who is sick, and as well as help out his mother who is also sick with cancer. I've spoken with my client and I've also spoken to the prosecutor's office. They have agreed to offer us probation, and we did accept that last week. We did request a plea hearing and plea paperwork. Therefore, we would like to be able to at least get him out for the time being, Your Honor, so he can at least get back to his life, seeing that they are offering probation and we have accepted it.
But how come we didn't just do a plea today?
I need to see, I don't know if I've received the plea papers yet, Your Honor. I know that last week on Wednesday or Thursday when we had a hearing, I did say that we would accept the offer that they were extending to us.
Did you send plea papers, Mr. Vandenberg?
No, Your Honor, we did not. We have to do that.
So let me hear, okay, go ahead, Mr. Nunez.
No, that's it, Your Honor.
Ms. Welch, if you
Therefore,
can.
we are requesting that you at least.
Go ahead.
I promise you I'll be good, ma'am. I promise you I'll show up to court. It's just my mother. Wait. Hold up, Mr.
Silva.
Just hold up, okay? Don't speak yet, okay?
Miss Welch, if you can see the violation notice on his PR bond, can you tell me what it was?
Yes, Judge. Let me go ahead and read it out for you right now.
Thank you.
Let's see. So it looks like he failed to report to the pretrial office monthly by phone since released from the El Paso County Detention Facility on December 8th of 2022. He was granted a PR bond on 12/7/2022, but has failed to report since he was released. Attempts were made on December 29, 22, January 25th, 2023, January 31st, 2023, to bring the defendant back into compliance with no success. On January 31st, Leonel Nunez provided the phone number for Behavioral Health Residential Treatment Center, but the facility confirmed that the defendant was not there. Defendant is in violation of his PR conditions.
Thank you, Ms. Welch. Okay, Mr. Vandenberg.
The only thing I can add is going through the notes, the last information that I have here is that I don't see that probation was accepted in the notes. It may have been, but it may not be in the notes. So I'll have, Your Honor.
You're going to put him on probation?
That's what the defense counsel says. The notes here say that it would be 12 months, state jail felony, And the offer would be, for the rec is 2.5, straight up.
So you're gonna put him on probation.
That's, yes, it's a possibility if they accept that, but that's for the rec, Your Honor. Not so much for the bond.
That is that is the recommendation that we had accepted, Judge.
This is the first notation that it was accepted.
No worries. Okay.
Have you seen his history, Mr. Vandenberg?
I have. He has a history of illegal burning, convicted of unauthorized absence from a community correction facility, probation revocation in 18 for possession of a controlled substance and evading arrest.
And you want to put him back on probation?
As I said, that was the representation that Mr. Nunez made that this was accepted. I don't see that in our notes that it was accepted, Your Honor.
Anything else on the bond?
No, Your Honor. I mean, I have spoken with my client. He knows that he has to comply with any conditions that the court sets. He does want
So
to.
let me stop you right there. Mr. Nunez, let me stop you right there. He didn't comply with PR bond. He has a 20-year history of not complying with probation. Right?
Yes, Your Honor.
The request to reduce the bond is denied. And Mr. Vandenberg, Mr. Nunez, I'm not looking to put him on probation. So think about that.
Thank you.
Okay.
Thank you.
Thank you, Judge.
Who's next?
Top of page 15, Judge. Annex, may we have Gutierrez, Adam Gutierrez.
But
Did this one have the consent to virtual plea?
No,
No,
Judge.
I had requested the plea papers, and then I got a second round of documents, and in the document wasn't included, but I did ask by way of email for that document from Mr. Vandenberg and also through the chat. And I guess it's getting drafted.
Your Honor, we just got notice that Mr. Montoya requested that, and I put a note in that we will draft that and send it out.
Let me ask, is that not circulating with your plea paperwork? Was it originally sent out to defense counsel?
I was not aware there was going to be an online plea, Your Honor. I thought it was going to be in person.
So a waiver needs to go out with every plea packet you send out, certainly with the folks that are in custody. Mr. Montoya, with that, I'm not going to do the plea today. We can bring her in tomorrow, assuming Mr. Marufo, we can get a request to the jail to have her transported. Because she's looking at probation, right?
Yes, Your Honor, 10 years deferred.
Mm-hmm.
What time would we be looking at tomorrow, Judge?
Marufo, are we going to be able to bring her?
I think so, Judge. I can make a preliminary call so they can put her on the list.
Tentatively, I'd say 9 a.m., Mr. Montoya.
Okay.
Okay.
All righty.
All right. If not, I'll see if we how soon we can do it. But those, anytime we're doing these Zoom pleas, it has to be in writing. It has to be in writing. And obviously when we're working with the annex, it does, it's not like when we're in person, you can do these things quickly. So Ms. Gutierrez, there is a little bit of a hiccup. We're going to try and get you transported tomorrow morning. Okay. Okay. All right. Thank you, Mr. Montoya.
Thank you, Judge.
Who's next?
Bottom of page 15, Judge. Annex, may we have Patricia Martinez.
well,
All right.
In cause number 2023-0D01734, State of Texas versus Patricia Martinez. Announcement of counsel, please.
David Vandenberg on behalf of the state.
Edward Hernandez, Deputy Public Defender with the Mental Health Unit on behalf of Ms. Patricia Martinez. Ready to proceed, Your Honor?
And Ms. Martinez is appearing from the jail annex. We are scheduled for a bond hearing today. Commissioner Hernandez, can you please tell me what her bond is?
$50,000, Your Honor.
Oh, yes, I have that written. Go ahead, you may proceed with your bond.
Yes, Your Honor. This is a really unusual case, Your Honor, and we're asking for the opportunity to let my client out. She, if I can just lay a little bit of background out, she has two young boys. The first one was born, and then she went into, she was diagnosed with postpartum depression. Then she had a miscarriage, and then she was diagnosed again with postpartum depression. Then she had another son, and she was again diagnosed with postpartum depression. It turns out, Your Honor, those were misdiagnoses. And from my research, 22% of all women who are diagnosed with postpartum depression actually have postpartum bipolar disorder. When she was arrested, the court noticed that she was in a manic phase. I guess the jail magistrate, and they ordered a 1622, and she was diagnosed bipolar, Your Honor. At this point, because it's gone unaddressed, because it was misdiagnosed, the incident that's alleged here, another behavior over the last year, she's just gone off the rails with these manic phases. When we first met her, after the court ordered a 1622, she was in her manic phase, and even we were not ready to ask for her release yet. But now at the jail, they've explained to her what bipolar is. They've put her on medication. Before this, she would self-medicate, thinking that her problem was just depression and she had to take something to make her happy. But clearly it's obvious now her situation was bipolar that was just undiagnosed. We would like to get her out, Your Honor, today and get her into the Takumi program so that during the pendency of this case and afterwards, if there's an agreement, she can continue getting services and medication through EHN as she stabilizes. She now knows what her situation is. She's done her own research on bipolar disorder to understand what's going on. I understand, Your Honor, that these are ag assaults and that although they weren't full assaults, Your Honor, they were, as I understand it from reading the reports, they were threats, that she was allegedly carrying a metal bar and threatening police officers. They actually found her under a car. I mean, she was just doing some really unusual, weird behavior, Your Honor. Again, we would request a full PR, but if the court cannot go full PR, if the court could just take it down low enough and put in whatever terms it desires. We have worked out that she can, for the time being, while she's stabilized through Takumi, and she is being stabilized through Takumi and EHN, that she can stay at 128 Casas Lindas Lane in Santa Teresa. It's right here by the border. It's her mother lives there, Your Honor, and she would live with her mother until we can get her re-entry and residency here back in El Paso. It's not far. She would be able to, because she has a Texas ID and is a Texas resident, she would be able to get her services through EHN and Takumi, as well as Texas Workforce Commission to get her a job and help with any kind of self-medicating that she's been doing. We've talked to Punto de Partida, and they're willing to help to transition her to just keep her on regular medication, Your Honor. The problem is it over years this developed, and fortunately that the silver lining in this cloud, Your Honor, is that this happened in Texas, and Texas has a 1622 requirement and a Takumi system, so that her condition was diagnosed and she's being medicated and she's getting the services she needs. And it's just a question of transitioning someone. As you can see, Your Honor, my client now is calm, quiet. That's not the way it was in the beginning. Now that she's being properly medicated at the annex, because they've diagnosed the bipolar and they're treating her specifically for that, it's a night and day change, Your Honor. And we'd ask for the court's help in having her get out and stabilize in the community, because the idea is for her to be a productive citizen from here on and not have these crazy bouts of mood swings between manic and depressed, Your Honor. I know it's asking a lot, Your Honor. Could we possibly have like a $150 bond, or if it's $1,000, just something that she can bond out with and continue getting services?
Let me ask a couple of questions. So where does she live? You mentioned she has children. Who has her children?
The father of her children has her children, Your Honor, and I've
And
spoken with him.
Are they together so that she has a place to live, or what's going on? Miss Martinez, I'm asking your attorney.
Yes,
Okay?
ma'am.
Your Honor, it's my understanding she would stay with her mother, but I have spoken with her husband, who is here. I think he's in El Paso, correct? Ms. Martinez, yes, he's in El Paso. Her children are here in El Paso. Granted, we just wanted a little bit of time to kind of make sure she's stable on the outside because we're transitioning medication, transitioning treatment. But I think for the first time in her life, I think we've identified what the problem is and it's being corrected, Your Honor.
We've confirmed that she can live with mom, Mr. Hernandez?
Yes, we have, Your Honor. Our social worker called, and if she can, her husband seems very supportive, Your Honor. If we can transition her to living with him after she's got her services, her medication, but he seems very supportive. They seem to have had a very loving relationship. It just started to fall apart over the years as her conditions became worse and worse, and she went out of control, basically.
Okay. I had one other question. Oh, I don't have access to Odyssey, so I need to ask. I made a notation here regarding some type of detainer. Is there something else holding her, or are we anticipating something? I don't know if you were able to see on the jailing. I thought I noticed some type of detainer, but maybe not. Maybe Miss Walsh, maybe you can help me with that.
I don't know if there's a detainer, Your Honor. During this period in the last year, she did get into some trouble in Florida, but I've spoken to Florida counsel. She's not received any conviction. She doesn't have another hearing there till October. So they're aware. In fact, we've turned over our medical records to counsel there because they were not aware of the mental health underpinnings of her situation.
Okay, no pending detainers. So wait a minute. So how long has she been in El Paso? And what did she pick up in Florida?
She picked up a number of crazy things, like I think one's a UUMV, which are alleging was a carjacking or something. She was just totally out of control, and then came to El Paso and she was still out of control, Your Honor. Like I said, the medication has made all the difference in the world, Your Honor. And now, like I said, from when we first saw her to when we see her now, I mean, she just needed to be identified. But Florida doesn't have a 1622 type setup, and they don't have Takumi, and that's what's really making a difference in her stabilizing, Your Honor. So we would like to keep her in Texas, but allow her she can go take care of whatever business she has to out there. We'll provide, we'll let the state here provide the care and the stabilizing, because the laws here are just better for it than they are in Florida, Your Honor.
Marufo, when I asked for the PSR, it's the entire PSR, okay.
Yes.
All right, so now I'm seeing the PSR with respect to Florida. That's a lot, Mr.
Your Honor, I agree. In a short period of time, she has gone completely out of control, Your Honor, and it's taken time to stabilize her, but I believe the proof is in the pudding, Your Honor, and you can see my client, for a change, she is kind of depressed, but she's very stable with medication. You know, and I think if she'd been properly diagnosed at the beginning as a postpartum bipolar instead of a postpartum depressed, this situation would have been taken care of from the beginning, and probably she'd still be at home with her husband and her children, because they were, according to both of them, had a great marriage, but she just started spinning out of control.
How does she end up in Florida, if you can tell me?
From my understanding, it was part of the craziness of forgive me for using that term, Your Honor, especially as a mental health attorney, but it was just part of her total spinning out of control that she just fled, left her, but she did fortunately leave her kids with her husband, you know, and just decided to start a new life in a place where she knew nobody. She's out of control. Things are going on. I mean, it's for somebody in a manic phase, Your Honor, I would suggest that's not exactly unheard of to do that kind of crazy thing when you're in a manic phase. And we did see her in a manic phase, Your Honor. But fortunately now We found a way to, we've gotten her the services she needs. Like I said, I think the best thing that happened to her is she came back to El Paso, and the laws here are just much, but this isn't the first state. I've had Arizona lawyers tell me the same thing, that Texas laws the reason Texas is the greatest provider of mental health services in their county jail system is because we have the laws that identify these problems and try to fix them. And it's working for her, and it's worked for other clients. But I mean, other states just don't have this kind of setup. They totally missed her manic bipolar mood swings, which this state caught immediately as soon as she was arrested, Your Honor.
So are there no resources toward a bond?
I would imagine it's very limited, Your Honor. But like I said, I understand that we are in a situation where the law might be interpreted as requiring that you have some kind of bond. That's why I asked for a very low bond, Your Honor, with whatever restrictions the court wants to place. I know it's an unusual situation, Your Honor. I'm asking a lot. I mean, I'm asking for trust in not only my client, but that the mental health system here can continue to stabilize her.
All right, is that everything, Mr. Hernandez?
Yes, Your Honor.
Mr. Vandenberg, go ahead.
Your Honor, within Portal, there is the mental collection for information form for mental illness and intellectual disability. It's sealed. I don't want to speak anything to that, but it'd be very good for the court to review that, I think.
I already did. Next.
If there's a chance of her gaining some kind of greater emotional and mental competency, that would be a wonderful thing. However, the state objects to her being released on a low bond for this. She can get inpatient counseling, inpatient treatment, but until there's some greater indices of stability in this, she could be a danger to the community, Your Honor. That's our concern.
So do you oppose a lowering of the bond?
Yes, Your Honor. We would suggest that if there is some kind of mental health treatment that she can receive in-house, that would be, I think, appropriate. But given the nature of everything that's been presented, she poses a danger to the community, Your Honor.
All right, I'm going to grant defense request to lower the bond, Mr. Hernandez. I don't think I'm going to get where you or she may need to be, but I am going to, I'm going to split it. It's going to remain at $50,000. It's going to be a $10,000 cash surety bond, $40,000 PR. She's going to report weekly to PR bond. There is a Takumi referral. She's to live with mother and not leave El Paso County and not change her place of residence without court permission. Use no illegal drug or alcohol. She's to possess no weapons, no firearms and no ammunition. Subject to testing, curfew, 9 p.m. to 6 a.m. unless she is working, going to school. I don't think there's an issue of having any contact with complainants. Any other conditions, Mr. Vandenberg, that you would request?
Curfew, Your Honor.
I added it.
May I just address 2 points, Your Honor?
Yes.
If she could be allowed to, she doesn't have another hearing in Florida till October. Like I said, I informed counsel, we're providing them with all the same medical information, but if she could be allowed to just leave for that purpose, if she has hearings, to just handle those. If they can do them by Zoom, great, but if not, then just so she doesn't get in violation there. The other thing, Your Honor, is if she resides with her mother, that's Santa Teresa. Granted, it's just a few feet from El Paso, but unless the court wants to put her with her husband and her children, which would be in El Paso.
Well, you all are, I mean, if you've discussed this with your client, is mom the first step? I mean,
yes,
I
Your
don't
Honor.
have an issue. Okay, then she will be allowed to leave El Paso County so that she can reside with mom. That's fine.
And we'll report before she goes to Florida for any hearing. We'll inform the court and PR officers. Your Honor.
Let me see. Is there a wreck in this case already?
That's a good question. No, Your Honor, there's no right.
And if we could wait a bit, Your Honor, I'm not in a rush. We're right now, our main concern is just stabilizing her mentally and setting her up on the outside so she gets permanent services. And then we can talk to the state.
So the Takumi language, Ms. Jasmine, also it'll be part of her conditions that she comply with any and all mental health treatment, to include taking medication, attending any type of appointments, all of those things. Okay.
Got it, Judge. Thank you.
Thank you very much. All right,
Thank you
who's
very
next?
much, Your Honor.
Thank you, Mr. Hernandez. Who's next?
Are we,
Bottom of page 14. Judge.
am I excused, Your Honor?
Yes, sir. Thank you.
Thank you, Your Honor.
Annex, may we have Denny Gonzalez?
We're not sure.
Ms. Marco, what case is this again?
Bottom of page 14.
Miss Guerra, you're upside down.
I know, I'm trying to fix it, sorry.
Danny Gonzalez.
All right, let's call it.
In cause number 2020-0D01521, State of Texas versus Danny Gonzalez. Announcement of council, please.
David Vandenberg on behalf of the state.
Lucinda Guerra for adult probation, sorry, Judge.
Mr. Huffman, is this your client?
Hi, I'm sorry, I was on mute. Rick Huffman on behalf of Mr. Gonzalez.
All right, we're scheduled for a probation, I'm sorry, pre-revo hearing. Do we have a current case summary?
Yes, Judge, I sent it in this morning to Ms. Carla.
Well, he's been in custody all this time, right? I see the May 30th. Ms. Guerra, please send it to the court. I don't see it here.
Okay.
Bench warrant, state's motion to. Perdón, I just found it. I'm sorry. Okay. All right, so CSO is recommending he be admonished, re-referred to EHN Takumi, and be given the injection. And that's when, in the past, he had said he wasn't going to take it, right?
No.
Sorry, Judge.
I told you I was gonna take it.
No, Mr. Gonzalez, I wasn't asking you. Isn't that part of the case summary, Ms. Guerra?
Yes, he was previously on the injection and doing very, very well. He said that he read up on some symptoms and wanted to be taken off. So he was put on orals. And then that's when he just decompensated and started using. But when I spoke to him in jail, he did say that he was, he would agree to be reassessed for the injection.
And we were having some issues, and I think this is one where he was asleep supposedly, so he wasn't 100% compliant with the meds in jail.
Right. And I got the most recent one, and he's only missed one day. He missed on the 12th of June.
And what was the reason for that?
It doesn't give me a reason. It just says refused.
Refused?
Yes, it's an R for refused.
All right. I remember this one. Mr. Huffman, do you have anything?
As far as the refusal on the 12th, I assume it was the same thing, Judge, because he was asleep. But I've spoken to Mr.
Mr. Gonzalez, are you
Hi,
talking?
I'm sorry,
Ryan?
Danny Gonzalez. And he has agreed that he's willing to take the medication. He's willing to do what he needs to do. Judge, he's got a good work history. He's got a lot of people depending on him. He's been in jail for a long time. And I don't think we're gonna have any issues going forward. Mr. Gonzalez, you know, he did all right on probation and he did have that issue with the oral medication. He was running into a lot of side effects with that oral medication, but he's more than willing to do the shot or whatever to get him back on track. And we're hoping, Judge, that the court gives him an opportunity.
What was the reason he didn't report?
Judge, so it was kind of confusing that he had been basically reporting to Ms. Guerra. I think I think this is the one where his PO was he got transferred to a different probation officer. There was an issue, Judge, that he tested positive for amphetamines and Mr. Gonzalez told me that it was because he had taken some diet pills from Juarez. He was like over 300 pounds, Judge, at one point.
No, Hoffman, the question is, why didn't he report December, January, and February?
Excuse me, can I speak?
No.
Judge, I think that was the point where the warrant came out. And so he knew that there was a warrant, and I think he had found out there was a warrant in December. Is that correct, Mr. Gonzalez?
Yes, sir. I reported every month until January. I didn't report February. The last two I spoke was to Mr. De Alba, I don't remember his Alarcon. I spoke to him on February and January when he called me and told me that he was my new PO. I had reported December and January. In January, I reported with Mr. Alarcon. And then February, I just literally just didn't call, just I messed up right there.
Thank
you. Ms. Guerra, do you have an indication that he did?
I don't show that he reported in December. I show that he called in. But that's not, we have to have face-to-face at that time. He was temporarily assigned to Robert Alarcon while I was out. And then he was rearrested on the 3rd of March, but he did report January, February.
On the bench warrant?
Correct.
Okay, Mr. Vandenberg.
I think the probation has stated it well. I just like to point out a couple of things. Mr. Gonzalez did not turn himself in as he was told to do. According to the notes in February, he was contacted to turn himself in. The only reason he was detained was because he was pulled over and they were going to take him into custody because of the warrant. So he has not shown compliance with anything in this. Rather, he has shown defiance towards his own agreement that he made with the court. And the purpose of the agreement and the purpose of this whole proceeding is to protect the people which were harmed by Mr. Gonzalez's prior acts. So we would ask that there would be at least ACOP time in this, Your Honor, because Mr. Gonzalez has not shown that he is actually willing to comply with the requirements that the court has imposed and which he has agreed to.
All right, anything else?
Not from the state, Your Honor.
Judge, I'd just like to point out, I think he's done about 100 days in jail on this warrant.
All right. All right. So if the state's at ACOP, he has been in custody. We've had that one hiccup, Ms. Guerra, in terms of the meds. What is the plan going forward? We're going to re-refer him to Takumi so that he can take the injection. We have him until 2025, right? And this is straight, right?
Correct, Judge.
Ms. Gonzalez, Ms. Guerra, you're his, well, as permanent as can get probation officer.
Yes, Judge.
Gonzalez, I am going to follow partially the probation's recommendation, which is to place you back on probation with a re-referral to the mental health services to include taking that injection that seemed to be working well for you. For my purposes, I'm not calling it ACOP, but the time that he's been in custody since he's been on the bench warrant will be considered as his sanction for not having complied. I will just tell you this, Mr. Gonzalez, if you fail to do one condition, that means call in, go to an appointment, take a medication, fail to report. Ms. Guerra, I don't want to wait until we've got 3 months of no reporting. One failure to report, I immediately want a bench warrant.
Yes, Judge.
If he's testing, I want him tested as he was before. It looks like he was testing, except for that one, he was testing negative. So continue, everything continues to be as rigorous as it was before. And I don't want to go with the standard, you know, we wait a while to see if he pops up. As soon as he's MIA, I want a bench warrant. What is this? For an injection administered if he qualifies, and OSAR for substance use. So OSAR for substance use treatment. So we'll go from there. So he can go ahead and be released, report immediately to Ms. Guerra. Ms. Guerra, do you need anything else from the court?
No, Judge, can I just ask him to call me when he gets out?
Will that be today?
If you're released today, call me in the morning.
All right, to the office?
Yes, sir, please.
All right.
Ms. Guerra, I want to know if he doesn't report, I mean, immediately.
Yes, Judge.
Carla, on that motion, we can go ahead and dismiss the motion.
Thank you, Your Honor.
All right, next.
Thank you, Your Honor.
May I be excused?
Thank you, Ms. Guerra.
Thank you.
Who's next?
Top of page 19, Judge. Annex, may we have Nevarez, Laura Nevarez.
Nevarez,
Yes, sir.
give me a second, we don't have Nevarez. The female?
Yes, sir.
Do we still have Vincent Perez?
Yes, Judge. If you don't have it, we can go to Vincent Perez, Annex.
What's the first name?
Laura.
Laura. Laura Isis, downtown.
Mr. Huffman, are you representing Laura Nevarez as well?
Yes, Your Honor.
All I have her in custody for 8 days. It's a PR revo. The only note, it's only set for a status conference. All we need to do is set a trial track on her, is what I understand.
Well, I was hoping hoping the state would agree to a PR bond. She was basically asked to do a class
You
and
need to file your motion. I'm not going to do an agreed PR bond. File your motion, please.
Okay.
Ms. Hernandez, on that one, on Ms. Laura Nevarez, we just need to get her a trial track, please.
Yes, ma'am.
Okay. All right, and this is Mr. Perez?
Yes, Your Honor.
Okay, go ahead.
In cause number 2022-0D04896, State of Texas versus Vincent Allen Perez. Announcement of counsel, please.
David Vandenberg on behalf of the state is ready.
Rick Huffman, on behalf of Mr. Perez, we are ready.
And did we have a consent to a virtual plea in this case?
Yes, Your Honor.
Okay. Mr. Perez,
Yes, Your Honor.
I just need to confirm with you, I do have you scheduled for a plea today. I need to confirm that you are in agreement to do this over Zoom rather than doing it in person in the courtroom.
Yes, Your Honor.
Okay. Mr. Perez, as I mentioned, you're scheduled for a plea. I have documents indicating as much, the first of which is, I'm sorry, I need to swear you in. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
State your name and date of birth for the record.
Vincent Allen Perez, 9/7/75.
Mr. Bettis, as I was saying, I have documents indicating that you intend to plead today. The first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Bettis, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes, Your Honor.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case? Mr. Huffman, have you had more than 10 days?
Yes, I have, Your Honor.
And did you explain the plea papers to your client?
Yes, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes.
Mr. Bettis, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Bettis, have you ever been found mentally incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes, Your Honor.
Are there any diagnosed conditions or anything undiagnosed that is preventing you from understanding what we're doing today?
No, Your Honor.
Mr. Bettis, did you go to high school? Did you graduate from high school?
GD.
Okay. Have you been able to effectively communicate with your attorney? In other words, have you been able to understand everything in terms of the advice on either going to trial or pleading in this case? Have you been able to do that?
Yes, Your Honor.
Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Frankfurt, Germany.
Okay, but you are a U.S. citizen?
Yes, Your Honor.
Okay, in this case, you're charged by indictment with the offense of aggravated assault with a deadly weapon. Sir, that is a second-degree felony, punishable by anywhere from 2 to 20 years or probation. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor. If this case had gone to court, the state would have been able to prove beyond a reasonable doubt that on or about the 5th day of November 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Vincent Allen Perez, hereinafter referred to as defendant, did then and there intentionally, knowingly, or recklessly cause bodily injury to Thomas Vacconi by striking him about the arm or hand with a piece of wood or a blunt object, and the defendant did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a piece of wood or a blunt instrument that in the manner of its use and intended use was capable of causing death and serious bodily injury, and is further presented that the said defendant used and exhibited a deadly weapon, to wit, a piece of wood or a blunt instrument, during the commission of an immediate flight from said offense, and is further presented that prior to the commission of the charged offense on the 4th day of April 2007, cause number 2007-0D01162, in the 171st District Court of El Paso County, Texas, the defendant was finally convicted of the felony offense of possession of a controlled substance, penalty group 1, between 4 grams and 200 grams.
Well, hold on. Are these enhancement paragraphs? Are we abandoning the enhancements?
No, Your Honor.
Well,
Wait, no, we have abandoned the enhancement. I'm sorry. There's not an enhancement in this.
Okay. What is the plea agreement?
Plea agreement, Your Honor, is that the state would recommend that the defendant be sentenced to 2 years confinement in the Texas Department of Criminal Justice with no period of community supervision. The state would request that exhibits 1 and 2 be admitted.
No objection, Your Honor.
States 1 and 2 are admitted. Mr. Huffman, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Bettis, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Pettis, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
It's signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of aggravated assault with a deadly weapon, and I will sentence you according to the plea agreement to 2 years confinement in the Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served. The court will also make an affirmative finding of a deadly weapon. Anything further, Mr. Vandenberg,
Not from the state, Your Honor.
Mr. Huffman?
Not from the defense, Your Honor.
Good luck to you, Mr. Pettis. Who's next?
Bottom of page 20, Judge.
Mhm.
Annex, man, we have Tarin, David Tarin.
Good night, sir.
Good afternoon, Your Honor.
Good afternoon, Ms. Parra. Thank you for your patience. Mr. Vandenberg, are you handling this case, these cases?
The Tarin ones, yes, Your Honor, I am.
So you made the rec in this case or in these cases?
No, Ms. Elizada made the rec in these cases. Your
That's correct, Your Honor. I was negotiating with Ms. Elizada up to now, and once he's been in custody approximately 341 days, Your Honor, together with just all of the cases that he had going on, some of the discussions regarding the facts and the complaining witnesses, Judge, but more than that, it was the time that he's been in custody, Your Honor, together with our understanding, if I recall correctly anyway, that his compliance on the case he was already on probation for was okay. He was reporting. I think the biggest issue was that he picked up the new offenses and didn't report them, Judge. But again, with close to a year of custody, he's had plenty of time to reflect. Judge, he provided me with certificates for classes and programs I was not even aware existed in jail, Your Honor, a total of 15 certificates, ranging from things like conflict resolution, career resources, behavior change. It's a program apparently called Corrections.
Mr. Parra, you're sounding way more official than we can be off the record. Let's not, I don't want you to have to repeat everything is my point.
I understand,
So
Your Honor.
let's go ahead and call it. Did we already call it?
No, Judge.
Let's call
Sorry,
it
Judge.
first. I don't want you to, you had a lot to say, and I want to make sure we get a record.
Thank you, Your Honor.
Mhm.
In cause number 2020-0D05125 and 2022-0D04719 and 2022-0D03572 and 2022-0D03238 and 2022-0D05573 and 2023-0D02136 State of Texas versus David Tarin. Announcement of council, please.
David Vandenberg on behalf of the state.
Honorable Parra, Your Honor, for Mr. Tarin.
And Mr. Tarin is appearing from the jail annex remotely. We were scheduled for plea hearings and a plea of true for his probation case. And I think this one was set last week. So just trying to, because the court was in trial, I actually did not have time to speak with Judge Speasney, so I don't even recall if the probation rec was enunciated at the final hearing plea deadline, was it?
Your Honor, it was just agreed that Mr. Tarin would be getting probation for the new cases and also remain getting back on probation for the probation case, Judge. But the probation case really wasn't addressed as much as the case of separate trial on the 16th.
Understood. Okay. And so it was, at least as far as I know, just understood that you all had reached a plea. I don't believe the court was ever unclear. So Mr. Vandenberg, if you are not fully informed on all the details on Mr. Tarin's cases, I need Ms. Elizalde here.
Let me see if I can get her. She's close by.
Mhm.
How was it accepted?
Okay. Can I sit? Hi, Judge.
Okay, so for purposes of the record, Miss Elizalde, I think had been the point of contact from the DA's office. So we had this set for trial last week. I think all the way through last week, I'd been represented that these cases were going to be tried one at a time, certainly within Mr. Tarin's rights. But I don't think the court was ever unclear, certainly with the probation case, that the overall rec, because we only have him on a state jail, right, on probation.
Correct, Judge.
I'm not putting him back on probation, period. I don't know what factored into the state's recommendation to put him back on deferred probation for ag assault, engaging, first degree, ag robbery, deadly conduct, and then another drug case. Is that all of them?
Yes, Judge. So, Judge, the way that it would have had to have been deferred, considering that they're 3G offenses, so I couldn't have done straight. I understand the court does not want to accept the recommendation, and we can continue on to trial if that's.
We have 200 jurors on Friday.
And Your Honor, prior to that, it was actually the Friday before the 16th that Ms. Elizalde and I had confirmed that the recommendation of probation is a recommendation that would be accepted by my client. Now, I'm not sure, Your Honor, if in hearing that the court would not want him back on probation, Your Honor is referring to the case he was already on probation for, in which case, Your Honor, I suppose, especially it being a state jail, that we take his time of 342 days in custody into account, perhaps time serve him on that, and then give him the opportunity to finish deferred probation on the new cases.
I am not going to accept a probation rec on Mr. Tarin, period.
And just to answer the judges, your original question, Judge, if I recall correctly, I did it based on conversations with victims, the defendant's age, his criminal record, and the fact that he was reporting. But again, as it seems pretty clear to me, the court does not want to accept the recommendation. We respect that. And should the court want us to continue on, then I would have to check availability since this is not officially set for Friday on all witnesses.
Was it? Oh, it was only set for a plea.
Your Honor, I was mentioning earlier that in addition to his being in custody 342 days, Mr. Tarin, more than any client, has apparently been making use of his time to better himself, Judge. There's apparently something called the Corrections Rehabilitation Institute, which allows for people to take programs and classes. Judge, he presented me with certificates showing completion of 15 different courses. Your Honor, he's very serious about getting out and beginning an education. I let him know that I would even ask the court to make it a condition of probation that he take an X amount of credits per semester. And Your Honor, just a little history as well as to his family and why I think he would be taking it extra seriously. He has a father, Judge, who did have to spend some time in prison. And thankfully, Your Honor, after spending that time in prison as a young man himself, he has not gotten into any kind of trouble whatsoever. And I know that that support that he has in his father, that example, that life lesson, as well as the contact that he has had with his father, Judge, it's my understanding he's expressed not only a desire to change, but in fact, his having done so already, and then an intense desire to continue doing so.
So then why isn't prison a solution here?
Your Honor, what we're hoping to, again, avoid, especially given his age, Your Honor, is the final convictions, Judge. Now, Mr. Tarin completely understands that if he's to plead guilty on these, Judge, we're looking at a punishment range that's incredibly serious. He understands that he not only would be looking at felony convictions, but that you could sentence him to well above what he would have been looking at had he accepted the state's original TDC offer. And Your Honor, we're okay with status hearings for the purpose of making sure that he's doing well on probation, for the purpose of making sure that he's registered to school and so forth, Your Honor. But I do think, Your Honor, that this is something that he would take incredibly seriously and that he'd demonstrate to the court is the right disposition for these cases.
What was the previous TDC rec?
Judge, the previous TDC rec was 5 TDC, but through negotiations, the final one had been 3, which included lesser included because he has F1s. And I'll just briefly add, Judge, if I'm allowed to say this, I did consider the amount of time that Mr. Tarin was in jail. And my concern is clearly he's extremely young. And the whole final conviction, I understand what Mr. Parra was saying is, but that essentially, whether it's 3 or 5, amounts to a time served rec if parole lets him out, a big if, right? But at least he has some supervision because he's going down through a horrible path. So it was not an easy decision to come to. I stand by the decision I made, but I completely respect the court's input and decision.
When he originally pled, I could have sworn we had him on more than one case because he had a handful of cases when he pled to the theft, right? Weren't some of them violent offenses?
I don't think he has criminal record, Your Honor. You're referring to juvenile?
No, and I apologize, I don't have Odyssey up. Here's the thing. I'm not totally insensitive. I'm not one to not accept a rec. So I'm happy to conference this with you all. I was just absolutely shocked. Let me ask, on these new cases, are they all out of the same incident? Are they have different dates of offense?
Judge, they have different dates of offense and it's almost the same, going to Isleta High School.
And all, if I remember correctly, Ms. Elizalde, within a fairly short period of time.
Correct.
Yeah, he was only out for how long? How long was he on probation before he picks up 1, 2, 3, 4, 5 new cases?
Can I click on this? Yeah. I don't think he was on for very long, and I do recall reading the report stating that he was reporting, but he did not communicate the new offenses to his PO.
Yeah, because he's not forthcoming. That's why he's not a good candidate for probation.
And Your Honor, this is before he spent almost a year in custody. That's plenty of time to reflect.
That's the only thing that keeps him from reoffending.
And Your Honor, with that being very much over his head in the event that the court does allow for probation, Judge, I mean, I still think that we have that to come back to. Your Honor, I was very much on board if the court is still considering this with the idea of perhaps having some sort of a status or some sort of a conference with Your Honor. I might be able to present.
I'll make myself available to you all, counsel, to informally conference. I don't really, I'm not a huge fan, not necessarily keep it from your client, but for example, in terms of the consideration the state was making in giving this type of rec, have all the complainants been notified about this plea?
Yes, Your Honor. If okay, I'd like to conference the rest of this conversation before I continue.
Well, I just want to make sure that they're aware what the state is trying to do with these cases.
Specifically, yeah.
So, yeah. So in terms of that, Mr. Parra, Ms. Elizalde, it's almost 5 o'clock today, so let's not do that. But I will absolutely make myself available to you tomorrow. You want to walk in, if you're in the courthouse, things like that, absolutely open, because this was shocking to me to see that there was a deferred rec, a probation rec, period. I understand, on some of these it's mandatory deferred, but no way, I'm not there. So maybe I need to be better informed.
Okay.
I welcome having that conversation. For now, I don't want to reset it for anything until we have that conversation.
Understood, Judge.
I know this is all on your radars. We're not going to lose track of Mr. Bud. Okay.
Okay, thank you, Judge.
Mr. Parra, thank you for your time. Thank you, Ms. Elizalde. Who's next?
Back to page 14, Judge.
Mhm.
Annex, may we have Collier?
Let me right off.
So on Collier, is that you, Mr. Huffman? Who did the plea paperwork for Collier?
I did.
Who's I?
Mr. Hoffman said that.
Yeah.
Okay, but Mr. Collier has 4 cases, right?
Yes, ma'am.
That's correct.
And 2 are on the docket, right?
That's correct. 2 will be dismissed as part of this agreement.
Is that reflected on the plea papers?
I Not direct. I thought it was, Your Honor. It's
It's not, and it rarely is. Please state, I cannot. I am tired of reminding everybody of all the mistakes. If you are going to be dismissing cases listed on the plea paperwork, we also need to make sure, Mr. Hernandez, that all of the cases get on the docket. Okay, now with that, Mr. Huffman, you sent corrected plea paperwork, is that right?
That's correct, Judge.
So what two cases, Mr. Vandenberg, are getting dismissed?
2022 0D0 5582 and 2022 0D0 4692. 5582 and 4692.
Is that the plea paperwork you fixed, Mr. Huffman?
No, Your Honor, the one that I fixed is the possession of controlled substance case, penalty group 1 over 1 gram. The only thing that we did, Judge, on the second page, it listed the offense as an assault. And we simply crossed that out and we put the actual offense of possession of controlled substance. That was the mistake, and that's what was corrected.
That's correct.
Your client see that?
No, Judge, I don't think he did. I don't think he
Mr.
did.
Collier, do you know what you're pleading to today?
I know that I'm getting 8 years deferred, and that's about it.
You don't know on what?
I believe my drug charges are getting dropped, and then it's gonna be for the family violence.
Is that what's reflected on the plea paperwork?
Judge, he's pleading to 1 drug charge, the 3rd degree, and then he's pleading to 1 assault with the previous conviction.
That's correct.
So 4692, right, had the wrong offense, so you all hand wrote possession between 1 and 4, is that right?
That's correct. 4692.
And then 5582 is the assault family violence, correct?
That's correct.
And both are 8 deferred, is that right?
Yes, sir.
All right. Mr. Collier, is that your understanding of what you're doing here today?
Yes, ma'am.
Call him, Mr. Muddyful.
In cause number 2022
Dismiss
0D0.
Mr. Vandenberg.
Pardon me?
I'm going to need my dismissals on the cases that are not listed on your plea paperwork, but are going to be dismissed.
I think we had those this morning at the hearing, Your Honor. So I'll walk them up to the court.
Go ahead, Mr. Muddyful.
In cause number 2022 0D0 4695 and 2022 0D0 4874 and 2022 0D0 4692 and 2022 0D0 5582, State of Texas versus Tyreek Collier. Announcement of counsel, please.
David Vandenberg on behalf of the state.
Rick Huffman on behalf of Mr. Collier.
Do we have waivers on the remote plea, consent to plea virtually?
Yes, Your Honor.
Mr. Muddyful?
Checking, Judge.
On 4692 and 5582.
Yes, Judge.
Mr. Collier, your attorney has sent over documents for pleas in 2 of these cases. And it is your right to have them conducted in person, but I have received a waiver and consent to do these via Zoom. Is that what you would like, to do it over Zoom rather than in person?
Yes, ma'am.
Okay, so I need to swear you in. Raise your right hand, please. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Go ahead and put your hand down. State your name and date of birth for the record.
Tariq Collier, 5/28/94.
Mr. Collier, I do have documents in front of me indicating your intent to plea, marked as State's Exhibit number 1 for each of these cases. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Collier, did you review State's Exhibit number 1 with your attorney and sign each of those documents?
Yes, ma'am.
Did you understand everything contained within those documents,
Yes, ma'am.
including the edit that was on, what was the one that got edited?
4692, Your Honor.
In cause number, the plea paperwork for cause number ending 4692 had listed the incorrect offense. The accurate offense on there is possession of a controlled substance in penalty group 1 or 1B in an amount less than 1 gram. Do you understand that?
Yes, ma'am.
And did you sign each of these plea papers with your attorney?
Yes, ma'am.
Mr. Huffman, have you had more than 10 days to prepare defenses in each of these cases?
Yes, Your Honor.
Did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
Yes, I do, Your Honor.
Mr. Collier, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Huffman, any reason to believe your client is not presently competent to enter his pleas?
No, Your Honor.
Mr. Collier, have you ever been found incompetent, mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor, psychiatrist who has found you mentally ill?
Like bipolar?
Like if you have any diagnosis, or is there something undiagnosed that is preventing you from understanding what we're doing today?
No, ma'am.
You've been able to communicate with Mr. Huffman effectively, in other words, been able to ask him all kinds of questions about all your cases?
Yes, ma'am.
Hey, did you graduate from high school, Mr. Collier?
Yes, I did.
And do you have any education outside of graduating from high school?
Currently, I was at Southwest University for automotive.
Okay. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today, sir. Are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso?
El Paso, Texas?
Yes, ma'am.
In cause number ending 4692, you were charged with the offense of possession of a controlled substance in penalty group 1 or 1B in an amount between 1 and 4 grams, sir. To that charge, what is your plea? Guilty or not guilty?
Guilty.
In cause number 2022-0D05582, you were charged with the offense of assault, family violence with a previous conviction. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Vandenberg, please summarize the evidence.
Your Honor, had these court matters gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about, and this is in case number 2022-0D04692, the on or about the 19th day of April 2022, and encouraged the presentment of this indictment in the county of El Paso in the state of Texas. Tariq Rashid Joseph Collier, hereinafter referred to as defendant, to then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants in an amount of 1 gram or more, but less than 4 grams. And the second matter, which is 2022-0D05582, the state would have been able to prove beyond a reasonable doubt that on the 3rd day of October 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Tariq Rashid Joseph Collier, hereinafter referred to as defendant, did then and there intentionally, knowingly, and recklessly cause bodily injury to Demetria Barry Cook, a member of the defendant's family, or a member of the defendant's household, or a person with whom the defendant has or has had a dating relationship as described by the Texas Family Code, by striking Demetria Barry Cook about the face or head with the hand of the defendant, and before the commission of the charged offense, the defendant had previously been convicted of an offense under chapters 19, 22, or 22 of sections 2003, 04, 2111, or 2511 of the Texas Penal Code against a member of the defendant's family or member of the defendant's household, or a person with whom the defendant has or has had a dating relationship as described by the Texas Family Code, namely the 23rd day of March 2021 in the criminal court number 3 of El Paso County, Texas, in cause number 4681. And there are 2 counts of that. The difference with the second count is that the indictment states that Mr. Collier struck Demetria Barry Cook about the face or head with a drink bottle. At this time, the state would ask that exhibits 1 and 2 in both matters be admitted, Your Honor.
No objection.
States 1 and 2 are admitted in each case. What's the plea agreement?
In both matters, Your Honor.
Yes.
The state recommends that the defendant be sentenced to 8 years community supervision under the deferred adjudication provisions of the Texas Code of Criminal Procedure, that he be assessed a fine in the amount of $2,000 with $2,000 probated, payable immediately or in equal monthly installments throughout the term. Additionally, the state recommends imposition of all the standard terms of conditions of community supervision, as well as that the defendant perform 250 hours of community service prorated monthly as a condition. And lastly, UAs and BAs, a curfew, no contact with the CW, and the standard terms and conditions, Your Honor.
Mr. Huffman, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Collier, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document for each case. It's entitled the Trial Court Certification of Your Right to Appeal. This is a document that explains your appeal rights, because these are plea bargain or negotiated cases. You do not have an automatic right of appeal. Mr. Collier, do you recall reviewing the trial court certifications and signing those?
Yes, ma'am.
They were signed by your attorney and signed by the court as well. So on your, oh, no. Motions for deferred adjudication. Mr. Collier, do you recall reviewing the motions for deferred adjudication on each of these cases with your attorney?
Yes, ma'am.
Mr. Huffman, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Your Honor.
Mr. Collier, do you understand that if you violate any condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for each of these offenses? Do you understand that?
Yes, ma'am.
And are you still asking the court to grant you deferred adjudication?
Yes, ma'am.
I will find in each of these cases there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 8 years. There will be a $2,000 fine. The entirety of that fine will be probated due to your indigency, which means that as long as you are in compliance with your terms and conditions of probation, you won't owe the fine. If you're ever out of compliance, they can come back and collect the entire fine. 250 hours of community service, urine and breath analysis, curfew from 9 p.m. to 6 a.m. unless you are working or going to school. You are to have no contact with the complainant and cause number ending 5582. There will be an affirmative finding of family violence in that case. Is there anything on the sentences will run concurrent, of course. Is there anything further, Mr. Vandenberg?
No, Your Honor.
Not from the defense, Your Honor.
Oh, in addition to that, once I receive them, cause numbers ending 4874 and 4695 will be dismissed. Anything else?
Nothing from the state, Your Honor.
Not from the defense.
Thank you, Mr. Collier.
Thank you, guys.
Is that everybody, or do we have anybody else?
I believe that's it, Judge. You did say that Sergio Lopez was gonna be reset, right, Judge?
Is that Mr. Yanez's client?
That's Mr. Hoffman.
That was mine. Yeah, Judge, we
That was
just got a
reset
new
for me.
offer,
1 week.
and we're gonna take it.
Then that would be it, Judge.
We have Perez Brandon and Soto Jesus.
Who is that, Brandon?
Perez Brandon.
I have that for a bond hearing.
And Soto Jesus.
Judge, for Mr. Brandon Perez, it was Denise Butterworth that called in the morning and said the family wasn't ready.
Okay. Do they have future settings?
They do. She asked if we could set them for July 11th.